Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. A sparking revolution, it's a truth-telling tale.
Against harassment, against Rob. And then we are going to get into a citing that I wanted to go over called State V Snyder, which Gingras cites in his motion to quash, comparing it to what Rob has been doing. And like always, Gingras cites to things that are not like this. There's huge differences, in my opinion. The judge may not see it that way, but this is how I would differentiate the two in what Snyder was doing versus what Rob has done. So let's get into that. Hello, LSB. Hello, Bruce, and everybody else. Hope everybody is doing well. Don't forget to like and subscribe. Replay crew, welcome as well. So, Gingras has two different blog posts up regarding this. So let's go to those. We're going to go to what he has labeled his blog as IAH ruling, which we don't know if this is the official ruling or not, but this is what we are going. We're just going to cover it. All right. So he posted this today, and he said order was received a few minutes ago, and then he crossed out, I'm not commenting further than that at the moment. I don't know why he needed to cross that out, but okay. So there's a link, which, all right, we'll go to that in a minute. He said, this is just a form that tells us apparently the outcome of the hearing. He says, apparently. Please don't joke about whether the form is real. Of course it is. It is live and available on ECR, so there is no basis to question whether it's fake. I don't question whether documents that Gingras has put up are real or fake. He has been consistent with not like lying about that type of stuff, or, we know if something is going to be filed or he has filed and it just hasn't been put on the docket yet. So in theory, the form may just be a temporary placeholder, i.e., it extends the IH for now, but the judge commissioner could issue a longer written ruling later that says something completely different. She still could reverse the IH. He says, but that seems unlikely. And in another blog post he is referring back to, he says, as I've said before, if the judge was going to reverse the IAH, she could have done that immediately with a one-line order or by checking a different box on this form. So I see no reason to expect a different result later. This form doesn't explain the basis for the court's ruling. Not surprising, given it's just a form. I assume there will be a longer written explanation later. If this is done in a minute entry, that will probably drop tonight in the wee hours, and I'll share it when it's received. Courts are not required to offer long or any explanations for their decision, but most good judges do that to help the parties understand why the court ruled the way they did. It also helps for the appeal, in my opinion. This form doesn't address our request for fees, nor does it say anything about the request to expand the IAH, which is something we need to talk about because the original IAH is just for him to stop harassing her, per se. The original IAH and stay away from her home and business and school and so forth. It doesn't include the things of asking him to stay out of the courtroom and the 500 feet thing. That's where there needs to be an addition, and that is not known whether she's granting the expanded request of the injunction against harassment or if she's just saying, "Hey, you can't harass her." Again, this implies the court will probably be issuing a longer minute entry order, hopefully later tonight, which covers that stuff. These types of rulings can be and often are appealed. I assume that Hayrob is going to appeal this if her injunction against harassment is granted. Of course, he's like the prevailing party for once. These rulings can be and are often appealed as the apparently prevailing party for once the choice to appeal is not mine. Personally, I hope no appeal comes from this. I want to see less litigation, not more. Well, the only way there's going to be less litigation is if your client quits doing things in court. So you want less litigation, you need to talk to your client. I have discussed this with Laura. At this time, I don't have any comments to share from her except to say she's happy with the decision. For my part, all I can say is, never mind, it doesn't really matter. Yeah, you don't need to comment. And the order was filed on February 24, 2026 at 11:30 a.m. And it has the injunction against harassment that was issued on January 20th, 2026. Says that they both appeared. The injunction against harassment listed above remains in effect. And that is it. So, yeah, we would like to know the parameters of this IH ruling. And then, oh, that's the same one. His 308 comment thing. What is that? Those are comments. Okay. 3:08 a.m. And we'll go to that in just a minute. Let's look at the comments. This is a document that explains the hearing happened and the original IAH is still in place. We need to get to the final ruling with the finding of fact and a ruling on the motion, quash, and fees. Exactly, Bruce. This is just saying that. Now, could he be correct in the fact that she could have just, gotten rid of the injunction real quick? Sure. But yeah, the judge could just do that, but this is a complex matter with everything involved. I don't think it's just black and white. No, they haven't ruled in Owen's favorite. This is just how Gingras likes to try to get his wins. I know it's not science, Bruce, about that it's on there. I'm just saying, yes, if you wanna question it, you can. I'm just saying I'm not questioning it. Um, and if it ends up being wrong, I'm not saying these things have or haven't been filed. This is just what we know. This is what Gingras has said. And it could just be paperwork that it could just be paperwork that the judge has to just fill out, because it seems like it was just a form to fill out at the hearing that states they both appeared on this date. And as of right now, the injunction is still in effect until I issue my ruling. That to me is all that that form says, basically, if that makes sense. All right. And then he has this 308 thing, which is kind of funny. The comments are funny. We can make a quash a word if you would like, Bruce. Just add it to the dictionary. Voice to text screws me over in the comments and on some things all the time, and it makes me sound so illiterate, and it pisses me off. All right. So this one, sorry I posted this around 3 a.m. from my phone. I was too tired to post a link to the actual PDF. And then he clicks to the actual order. All right. This is apparently filed 2/24 at 8 a.m. 8 a.m. And it's the minute entry for that, which, yeah, apparently, according to Gingras, because I looked before I went to bed last night, that there is a docket dump that happens, I guess, around 2 a.m. in Arizona. Yes, we should always check the ECR for sure. And I'm just not going to look for it. And if it comes out that this is wrong, I will make a video saying, don't trust Gingras and his documents in the blog. Right now, he's not done anything to make me distrust that. But always do your own research. So this is the minute entry from the meeting. He says in his 3 a.m., he says, here is the actual order. No, this is not the actual order, in my opinion. Prior to today's hearing, plaintiff exhibits 1 through 17 and the defendant's exhibits 18 through 27 are marked for identification. It was done in courtroom 514 in the East Court building, 9 a.m. This is the time that was set for a hearing on an injunction against harassment. Plaintiff Laura Owens is present and represented by counsel. Gingras, defendant Rob is presented and represented by counsel, Mr. Kelly. A record of the proceeding is made digitally in lieu of a court reporter. Oh, so they didn't have a court reporter for this thing. And it's no big deal to Laura. No court reporter, and she's not throwing a huge ass fit like she did in California. Well, if there's no court reporter, then I'm not coming. I'm not being questioned if there's no court reporter. But here, it's fine. Why the change, Laura? Like, this was the same shit that was going to happen in California. But no biggie here. That's interesting. Laura and Rob were sworn in. Owens testified. Discussion is held regarding a supplementation to the petition for injunction against harassment issued on January 20th. Plaintiff is provided a supplement to petition to complete and sign. The court will allow brief recess for defendant and defense counsel to confer as to whether continuance will be requested due to the supplement to the petition. Court stands in recess at 9:16, 9:19. The court reconvenes with the respective parties and counsel present. A record of the proceedings is made digital in lieu of a court reporter. Let the record reflect the courtroom clerk serves the supplement to the petition in open court. Let it further reflect the defendant signs an acceptance of the service form in open court. Let it also further reflect the parties received copies of the supplement to petition in open court. Having an opportunity to review the supplement to the petition, defendant waives a continuance of this hearing and court proceeds with the hearing date. Owens resumes testifying. Discussion is held regarding plaintiff's medical conditions and other legal cases involving plaintiff. Plaintiff's exhibits 1 and 3 through 13 are received in evidence. So number 2 was not. Bruce is always bringing up and making our thought processes better. Do not just take people as their word. We need receipts. Who needs a court reporter when you have the Conor McGregor of Credit Karma? 10:31, the court stands at recess. 10:38, the court reconvenes with respective parties and counsel present. A record of the proceeding is made digitally in lieu of a court reporter. Closing statements are presented to the court. Having considered the testimony and evidence presented, and for the reasons stated on the record, it is ordered taking this matter under advisement, filed to the petition and acceptance of service, 11:05 a.m. Matter concludes. Later, pursuant to the orders entered and there being no further need to retain the exhibits not offered in evidence in the custody of the clerk of court and pursuant to the notice provided in minute entry dated February 11th, 2026, let the record further reflect that the plaintiff's exhibits 2, 14 through 17 and defendant's exhibits 18 through 27 are hereby disposed. And that's it. It's taken under advisement. This to me is not an actual ruling. And unless he's saying that the ruling right now is just taken under advisement. So I don't get that. No. How do I don't know what I just did. Okay, whatever. Okay. So let's go back to this. Who knew that Credit Karma was all encompassing? I did not. All right, so we're going to go back down to this. And that's it. Okay. His comments on this are hilarious. So I don't know who Birdie is, but Birdie states, I just can't believe you're still fighting for her after she seemingly threw you under the bus in her bankruptcy hearing. I know you cannot answer, but I gotta wonder, did you really mess up / misunderstand her affidavit and she just now told you or ... Oh, I also don't expect you could have been interviewed for the new podcast Love Trapped, but any thoughts? Gingras, with his smug ass face, says, I talked to them, but I haven't listened to any of it yet. I did see their intro claimed that there were thousands of forged documents. To my knowledge, that's a blatant lie, so I'm very disappointed to see yet another journalist allow money and hype to overcome facts. Sir, thousands of forged documents is possibly hyperbolic. But you being a king of being hyperbolic should understand it's not a lie. Could it be an exaggeration? Yes. Also, do we know that there's not thousands? We don't. But he's like, "Oh, they used exaggeration in their story. So, you know, they're just after money." What are they supposed to say? There were 5 forged documents, which we know there's more than 5, but seriously, that's what you're that's why all of us are liars. All right. And then he responds to, Laura didn't throw me under the bus. What happened was both clear and sad and kind of infuriating. That that Jennifer person. Oh, that Jennifer person. You mean the US trustee's attorney? That Jennifer person made false statements to Laura during the meeting of creditors. Did she? Okay. Right. There's probably so much more. So this Jennifer person apparently made false statements to Laura during the meeting of creditors. Well, then why didn't Laura say they were false statements? Specifically, she asked Laura why she had claimed to own more than 5% of her parents' LLC, Quartet Farms. Laura never made such a claim, so that really left her upset and confused. Um, if she Yes, the document, she checked a box and it specifically asks about the 5% ownership and she listed things. So, no, that's not a lie. Once again, you're gaslighting. Laura never made such a claim, so that really left her upset and confused. Jennifer then jumped into that $450,000 issue with a bunch of improper, misleading, and confusing questions. No. The reason it's so confusing, David, is because one second Laura says it's from a money marketing or that Clayton knows that it's a money marketing thing. Just because Clayton knows it's a money marketing account doesn't mean that the US trustees know that Clayton knows that it's a money marketing thing. But one minute she claims it's a money marketing person, investor, and the next minute she says that it is her own money in her checking account and it's hers. Then the next minute it's not hers. Her mom has money. So it's not improper, misleading, and confusing. It's the fact that your client confuses everything because she can't keep her story straight. And she says whatever is convenient for her at that time. So, yeah, maybe your client shouldn't lie so much. She was clearly playing to an audience rather than doing her job. Oh, yes, because the United States government wants to play to an audience right now with Laura Owens. That caused Laura to try to push back by explaining the truth about what happened, but she was so rattled by Jennifer's unprofessional conduct, Laura literally shut down and couldn't concentrate. She said so. Um, no, Jan doesn't have that money either, Tiff. I'm just saying. She's like, my mom purchased it with her own money. So whose money is what? What money did they use? Was it her mom's money? Was it a money marketing? Also, the money marketing thing has been edited as well, that's been submitted, maybe not to the trustee people, but the one that was submitted in the paternity case definitely had been edited. So it's funny that every time Laura is questioned, it's unprofessional conduct when somebody questions her. It is They are always playing to an audience when she's being questioned, and she always gets so upset when she get asked questions. Like, people don't act like this. Well, he wasn't her attorney, DM in MT. He wasn't her attorney for this meeting of the creditors thing. He didn't try to be her attorney until right after this, when he sees Laura is in over her head and she needs help. Because we can't let Laura just sink herself. Well, he likes to be hyperbolic and lie as well. I can't remember what the line is. We may bring it up and listen to it in just a second. That is true. He could have texted her. She could have had him on FaceTime. And Laura can push back and explain the truth about what happened, but she doesn't need to be rattled. There's no reason to be rattled about things if you're telling the truth. Laura literally shut down, couldn't concentrate, said no. Hopefully the court will allow me to step in and formally represent Laura in the main case. And then he goes on to continue. I won't tolerate any further BS like what I saw from Jennifer. I have dealt with people like her many a times, and I will ensure she follows every rule to the letter, or she will face the consequences if she doesn't. What consequences? Nobody's scared of you, David. The attorney for the U.S. Trustee's office is definitely not afraid of you. Having said that, the $450K issue is such a stupid, meaningless mistake. It was an effing typo. Oh, it's an effing typo. But she says, which was my fault that was missed. Keep in mind, Rachel Mitchell knows all about this, but she has not charged Laura with anything related to the $450K thing. And no, Jennifer isn't going to charge Laura with any crime over that either. A typo in a court case is not a federal crime, so the DOJ has no jurisdiction to bring whatever charges over the mistake, even if it was intentional, which it's not. If Jennifer has a shred of integrity, she will spend 5 minutes looking into this, and then she will agree that this is a total nothing burger. And then he closed comments because he doesn't have anything else to say. So those are his things. Okay. That he says on those. Yeah, it's just okay. So let's remove that. Right. if they were true and she signed them herself. Exactly. All right, let's bring up that thing that he says in the trailer. We'll listen to it. Oh, good. The justice people are putting things up about things. Good. And correcting the record. So we'll share this tab. Let's see. We're going to add this to the stage. Oh, dang. Anyways, if you go on Twitter, it shows you that it is within 4 years before you filed the bankruptcy. Did you own a business or have any of the following connections to any business? She checked off a member of a limited liability company or limited liability partnership. She also checked off an officer, director, or managing executive of a corporation. And then she also checked off owner of at least 5% of the voting or equity securities of the corporation. And then she says, check all that apply above and fill the details out below. So here it does say an owner of at least 5% of the voting or equity securities. And maybe she's saying, no, it's just, I have 5% of the voting. Quartet Farms, Lismac, Keybacker, Stylet. And so, yeah, it's just so stupid. Yeah, everything's a typo if Owens and Gingras does it. If anybody else does it, it's just blatant lies for money and everything else. It's so disingenuous. Okay. Now let's go to so much BS. Is it going to? All right, here we go. All right, we're going to share this. Share screen. All right, here we go. Introduction to Love Trapped. 2 episodes will be dropping this Thursday, the 26th, for this podcast. And then every new episodes will, I don't know if it's going to be 2 at a time or if it's, if it's going to be 1 every time after the first 2. But let's listen to what Gingras says. Here we go.
Tonight, former Bachelor star Clayton Echard.
The Bachelor's Clayton Echard. He had a brief romantic
Tonight, former Bachelor star Clayton Echard.
The Bachelor's Clayton Echard. He had a brief romantic encounter with this woman,
who later claimed she was pregnant with his twins.
who he says tried to destroy him.
I mean, this is really an unbelievable story.
I have done nothing except get pregnant by the fucking Bachelor!
This story starts with a very familiar scene, an at-home pregnancy test.
It was just her and I, waiting for the results.
The woman he was standing next to was essentially a stranger, someone who had reached out to him on LinkedIn. They'd only hooked up once.
One line shows up right away.
Many of us have been there before. Whatever result you're hoping for, the wait is excruciating.
And then the second line starts coming in. And I'm like, wow, she's actually pregnant.
This moment changed Clayton Echard's life forever, but not in the way he expected.
Every time you think it couldn't get crazier, it just does.
Over the next 2 years, he would be thrown into the spotlight again, this time becoming the center of a story that was spiraling out of his control.
The media is here. You know that this case has gone viral.
The dating contracts.
Stalkerish behavior.
She sent me over 500 emails and text messages.
Agree to date me, but I'm also suing you.
It's just chaos.
Had she not gone public, things wouldn't be where they are today.
Please search warrant.
It's a story about who you believe and why you believe them.
It's not about men versus women. It's about victims versus abusers.
It would take a group of strangers all across the country to finally prove the truth.
My bullshit meter went off right away.
They found information that I don't think any private investigator could have found.
The smoking gun of the entire case discovered live.
Every day was a new twist.
She makes up all these characters and she creates fake personas.
This is unlike anything I've ever seen before.
There's so much collateral damage from this story.
What would come out was a whole group of victims who'd fallen into the same trap.
I got a DM that said, hey, you need to look into this court case. You're not the only one.
Bingo. This shit doesn't happen twice.
I'm Stephanie Young. This is Love Trapped. And this season, you'll hear from Clayton Echard himself.
This is something that's more common than people realize. It's called getting trapped.
There's no way
Listen to Love Trapped starting on February 26th on the iHeartRadio app, Apple Podcasts, or wherever you get your podcasts.
Ms. Owens, I'm going to ask you one final time. You were never pregnant by Clayton Echard, correct?
Try to leave.
So that is what it says. I never heard anything about 1,000 documents. So don't know that. Let's just see if something else came in that not knowing. Let's go. I don't know. Where did you see that, Marcy? I didn't know she granted a 1-year restraining order. I don't know where that's at. Haven't seen it. If it is true, like I said, it wouldn't surprise me if it was partially granted or if it was granted because of one certain thing, but yeah, so apparently she's just a troll. Or did she delete it? It's not deleted on mine, so I don't know. Oh, I wonder, some people, I would have to go and check. Some people can see things. Let me see here. I'm gonna, okay, I'm gonna keep that muted. That's funny that it's muted on her end, but it wasn't muted on, it wasn't done on mine. Okay, but we haven't seen any official reading of that. It could just be a troll. I know sometimes people, what does this show me? Anyways, I know some people are able to like look and see how long somebody's been a part of YouTube and stuff like that. But anyways, okay. Back to what we were talking about. Okay. Now I want to bring up Gingras cited in his motion to quash this State V Snyder thing. And then there was another one that was State v. Williams. But let's look at State v. Snyder that he talks about in the appeal. All right. So we're going to present that. State v. Snyder is very different than what Rob did. And we're going to embiggen this. So it was Arizona Court of Appeals, Division 1, State v. Snyder. The judgment did become affirmed, and it was an appeal from the Superior Court of Maricopa County. And so Snyder wants to appeal his conviction and sentences for one count each of harassment and aggravated harassment for the following reasons. We affirm. So, and then it talks about the facts and procedural background. So they recite the facts in light most favorable to Snyder's convictions, which they're supposed to do. In March 2018, Snyder and Beebe, which is they're identifying the victim by their initials, met an online dating app and went on a date. Around that time, Beebe had opened her own interior design contracting firm and told Snyder about her business. By April 2018, Beebe and Snyder had gone on a few dates and spent Easter together. Shortly after Easter, and while Beebe was out of town, Snyder created social media accounts for Beebe's business without her knowledge. So, yeah, I would like to know, like, if they, let's see here. Can I? Don't we all need a cocktail, Bruce? Okay, I'm modding Bruce and Big Tiff as of right now. Whether they asked for it or not. They don't have to do those duties, but if they're ever around, they can mod. So, all right. So this would be like if Rob made like a business Facebook page or Twitter page or something like that for Laura, and it didn't tell Laura about it. He was just running. He's just running a Quartet Farms like Facebook page without their knowledge. Like, that's not happening. Or if Greg was to have done this with one of her businesses, because, you know, Greg's the computer hacker, apparently. Joking, he is not. But he apparently later texted her about it. Beebe continued to see Snyder, but began having serious concerns about him in May of 2018. By this time, Bibi had not received any information regarding the social media accounts Snyder created for her businesses. Maybe she's not on Facebook. Who knows? Bibi ended the relationship with Snyder, stopped all contact with him on May 19th. So they dated a month, less than a month. And at that point in May 19th of 2018, blocked him on all social media accounts. So Snyder is not supposed to be able to contact her from his account. And the footnote just says blocking is a process whereby social media users prohibit other users from viewing or tagging their social media profile page, unfriending or blocking someone on Facebook. All right. After the relationship ended, Snyder began sending Bibi various communications which scared Bibi. She then contacted a private investigator specialized in computer forensic and cybercrimes investigations who recommended she hire an attorney. Rob was not sending communications various ways. Not happening. May 28th. So they broke up on May 19th. 11 days later, Bibi sought an ex parte order of protection against Snyder. A few days later, Snyder posted a series of videos on his social media account concerning the order of protection. On June 1st, Snyder was served with the order of protection and posted several more videos about the order of protection. Which, yeah, Rob said, yeah, I've got my order of protection. Name is, or address and all that, blacked out. Bibi's clients and Bibi's former employer order protection and posted several more videos about the order protection, Bibi's clients, and Bibi's former employer. So he is talking about her clients, which could mess her business up. And he is talking about her former employer. He's messing with her business. Several days later, Snyder posted 2 more videos referencing Bibi and the order of protection. On June 7th, Snyder obtained an ex parte order of protection. No, there's difference. Is his handle not? It should be blue. It's blue now. Bruce's handle should be blue. So, yeah. I just didn't have mods because I never really had a reason to. All right. But this order of protection prohibited Bibi from several locations, or excluded Snyder from several locations, including her place of employment. Bibi contested Snyder's order of protection against her. The court ruled in Bibi's favor and dismissed the order. Snyder also contested Bibi's order of protection against him. Okay, so Snyder, let's try and big in this some more. On the 7th, Snyder did a retaliation order of protection against Bibi, which prohibited Bibi from several locations, including her place of employment. That's so stupid. And then Bibi contested Snyder's order of protection against her, and the court ruled in Bibi's favor. So Snyder's retaliation ex parte communication was dismissed, and they were like, yeah, no, this is BS. The court ruled in Bibi's favor and dismissed the order. Snyder also contested Bibi's order of protection against him. On June 25th, the court held a hearing and affirming Bibi's order. A detective arrested Snyder after the hearing. Great. Here's why that is so different from Rob. The state charged Snyder with 1 count of harassment and aggravated harassment. ARS 1329-21. At trial, the court denied Snyder's motion for judgment of acquittal under Arizona Rules of Criminal Procedure. Rule 20, the jury convicted Snyder as charged, and the court sentenced Snyder to 18 months under supervision probation. Snyder timely appealed, and we have jurisdiction under ARS 12120. So what is... Let's see here. What is the difference? Difference. Let's go here. Okay. Aggravated harassment is a more serious form of harassment, which is why it was criminalized. And it includes intimidation or terrorize the victim, such as credible threats of harm, unwanted physical contact, or harassment motivated by bias against protected classes. And it's a felony. Whereas just regular harassment can be classified as a misdemeanor. So Snyder is doing aggravated harassment, meaning he's threatening BB's life. All right. Rob didn't do that. Oh, it's not a typo for sure. It's not a typo because he cited this. He made a blog post about it. He definitely means State V Snyder. Yeah. This lawyer is stupid. He cannot make correlations. My 2-year-old grandson can make better correlations than Gingras. All right. So the discussion. Rule 20. Snyder argues the court erred by denying his Rule 20 motion as to the aggravated harassment charge. He says, we review a denial of Rule 20 motion de novo, viewing the evidence in light of most favorable to the sustaining verdict, which de novo just means as new. Like wiping away everything and just looking at it as if it's a brand new thing and that there's been no ruling or anything on it. In conducting our review, we compare the evidence against statutory requirement elements of the offense. And then they cite some cases, and he says, and do not reweigh the evidence to decide if we would reach the same conclusion as the trier of fact. A judgment of acquittal is appropriate when no substantial evidence exists to warrant a conviction. Substantial evidence is more than a mere scintilla and is such proof that a reasonable person could accept as adequate and sufficient to support a conclusion of defendant's guilt beyond a reasonable doubt. If reasonable, people could defer as to whether the evidence establishes a fact in issue. That evidence is substantial. Substantial evidence may be direct or circumstantial. A person commits harassment under ARS 1329-21 if, with intent to harass or with knowledge that a person is harassing another person, the person anonymously or otherwise, contacts, communicates, or causes a communication with another person by verbal, electronic, or written means in a manner that harasses. A person commits aggravated harassment if 1, the person commits harassment under ARS 132921, and 2, a court has issued an order of protection against the person in favor of the victim, and the order has been served and is still valid. Harassment means conduct that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, seriously alarms, annoys, or harasses that person. So they first say Snyder does not dispute that he was the subject to an order of protection in favor of BB that was served and valid between June 1st, 2018 and August 1st, 2018. But Snyder argues the state failed to prove that he contacted or caused a communication with BB between June 1st, 2018 and August 1st, 2018, because he did not directly send BB any message while her order of protection was valid, and BB only became aware of his social media posts concerning her when third parties showed them to her. Which is true. You cannot contact third parties to get your message to a certain person. Rob did not contact any person to get a message to Laura. Now let's go into how Snyder involved third-party people to get messages to her without directly contacting her. Snyder cites to 4 out-of-state cases to support his argument, but we find them either unpersuasive, inopposite, or immaterial to the present case, which to me is what Snyder is to Owens v. Hayrob. For example, Snyder cites to a JAW versus State, which is a Florida appellate's 2016 case in which the Florida Courts of Appeals found that public social media threats were not sent to a specific victim, did not violate Florida law. But the Florida statute applies only when the defendant sends or procures the sending of communication. So that's in Florida. But in contrast, Arizona's laws applies when a defendant contacts, communicates, or causes a communication with another person. So did Rob cause a communication with another person to go to Laura? No. Because Arizona's statute contemplates a broader range of activity, JAW is distinguishable. So they said that case doesn't apply in Arizona because we do it differently here. And Snyder's reliance on cases from Ohio and Arkansas is similarly misplaced. State v. Smith and Knight v. State, Roberts v. State, etc. In Smith, the timing of events meant that the threatening communication could not have been intended for the alleged victim. The gun photo was not posted on Smith's Facebook page until the 27th. The city's argument is based on the date that Farrell saw the friend request, who was sometime in March, but the burden on the city was to prove Smith's purpose at the time the friend request was sent. In Knight, the statement at issue was made to another inmate and only overheard by a detention officer over an intercom system. In Roberts, a teacher found a hit list in a student's notebook after the student attempted to hide it. Okay, yeah, those cases definitely don't. Sounds like Snyder had a lawyer like Gingras, personally. In both cases, the inadvertent discovered statements directed to another party was insufficient to establish the defendant had the purpose of terrorizing. The inadvertently discovered. Yeah. Laura inadvertently discovered Hey Rob's content. Actually, it wasn't inadvertently because she purposely looked for it. So that it, because it was inadvertent, it was the things that those people did did not have the purpose of terrorizing. Just like Hey Rob does not have the purpose of terrorizing and harassment. His purpose is to inform and report on an active case. Which was required under that. Nothing the defendant must intend to fill the victim's intense fright. Right now it's still in effect, Kashmir, and it's just because an order has not been finally made. So until we have a final order that says something, we don't really know. It's still continued as of this point. All right. The substantial evidence yes, an order of protection and IAH are different. They are. And I think what Gingras and Laura are trying to do is make the IAH an OP or an RO and a restraining order. And that's to me what they're trying to make this injunction against harassment, because so there's difference. They are trying to make something. Well, if she would have filed for a restraining order or an order of protection, maybe, in my opinion, she could keep Rob out of courtrooms and different things like that. But all she filed for was she wanted him to stop talking about her on the internet. Exactly. They do not want Rob in that courtroom. But the thing is even if they don't have Rob in that courtroom, somebody else is going to be there reporting on the case. So it really doesn't fix anything. Also, Rob is still going to be able to go to Gingras's hearings because Gingras doesn't have an order out on him. Nope. And this is why I think it's dangerous, because if this is allowed, that a content creator can't go on and expressly say things, that's why I think the order needs to clearly lay out what the harassment, like, what is it for? Is it because she needs to state that the talking on the internet is not a part of why, if she does decide to do the order, she needs to state that the stuff that was said online has nothing to do with the order. That was not a part of it, because if she rules and says that things done online and all that, that could be very dangerous for every content creator going forward reporting on anything. It infringes on First Amendment rights. Yeah, Laura doesn't need to go there. They could try that, and I said that the like last night or the night before, whatever it was. All right. So, in contrast, those out-of-state authorities in Arizona, neither direct contact nor purpose of terrorizing is statutorily required. And I think that's a thing, because purpose of terrorizing harassment is not Rob's purpose of doing what he's doing. And I think that makes a huge difference. Okay, rather harassment is conduct that is directed at a specific person. There is a substantial evidence indicating that Snyder's conduct was directed at BB, including him posting a video on his social media account that showed the order of protection with BB's name and address on it. This is where Gingras was like, see, look at this picture. Snyder also argues that no contract occurred between him and Bibi after the order of protection was served on June 1st. What? Oh, no contact, not contract. Snyder also argues no contact occurred between him and Bibi after the order of protection was served on June 1st. That's fine. But it tells you to stay away from these places in your no contact order. It doesn't say stay away from these places if they're there. It says you cannot go there. Whether that person is there or not, you cannot go there. So that's misreading your contract, your order of protection. But under the statute, a person commits harassment if the person contacts, communicates, or causes a communication with another person by verbal, electronic, or written means in a manner that harasses. There is substantial evidence that Snyder caused a communication with Bibi after he was served with the order of protection. But for and proximate cause must be established in a criminal case. Also, this is a criminal case, not just a regular harassment case, which means that requiring proof of causation for manslaughter, aggravated assault, and criminal damage while citing ARS. Okay. To establish but for cause, the state had to present evidence that, but for the defendant's conduct, the victim would have not been injured. To establish proximate cause, the state needed to present evidence showing that the difference between the results intended by the defendant and the harm actually suffered by the victim was not so extraordinary that it would require unfair to hold the defendant responsible for the result. And they're citing some cases. Intervening causes become superseding when the intervening acts of another were unforeseeable and appear extraordinary. They continue on with a proximate cause by may be interrupted only when another cause with which the defendant was in no way connected intervenes, and but for which the injuries would not have occurred. Here, Snyder caused I hope so. And I hope we can hear about that. Yes, but for Laura Owens, I would not have a headache. And but for Gingras. Yeah, no making contact. No impersonation. Yeah, no impersonating. Like, that's an easy fix. But he should still be able to talk about a public case, in my opinion. Here, Snyder caused the communication with Bibi, i.e., but for Snyder's posting the videos on his social media accounts, they would not have been communicated to Bibi. Other evidence further shows that Snyder's conduct proximately caused several communications with Bibi. For example, Snyder recorded a video outside Bibi's place of employment, posted the video to his social media account, and tagged Bibi's primary client's social media accounts. So here's where Rob's stuff is different. Rob is not reporting outside the casita, all right? He's not doing that. Rob is also not tagging Laura's clients, Laura's attorney, Laura herself, Laura's parents, Laura's sister, anybody like that. They are not the same thing. Snyder went to the business. He was told not to go to the business. Whether Bibi was there or not, he still went to the business. Huge violation. And he also tagged people. And when you tag people like that, it is so that that person will bring it up to Bibi. Because what is the point in tagging BB's clients? It's to do things to BB's business, and is also so that BB's client can be like, what the hell is this? Do you know anything about this? This dude just did this. And it's so dumb. Like, this Snyder dude is a complete cray-cray because, oh my God, they dated a month at max, and he's doing all this nonsense. Much like Laura, because somebody didn't want to be with him. That's how they're similar. Snyder and Owens, both a bit cray-cray. BB's primary client, who was also BB's former employer, then contacted BB about the video post. Similarly, I don't like that word, similarly, Snyder posted another video that included BB's business name and tagged another of BB's clients in the video. So that's a different video that he did. Tagged somebody else. The client communicated the post to BB. Additionally, several other people contacted BB about other videos posted by Snyder between June 1st, 2018 and August 1st, 2018, thus holding Snyder responsible for the resulting communications with BB is not so extraordinary that it would be unfair, nor were the resulting communications unforeseeable. Yeah, they were definitely foreseeable because you tagged people that would tell her. So then they said, a person of sound mind is presumed to have intended the natural and probable consequence of every act deliberately done. The court did not err in denying Snyder's Rule 20 motion as to the aggravated harassment charge. So, no. Your harassment charge sticks, Sir Snyder. Then we go with the free speech challenge. Snyder argues that ARS 1329.21.01 has applied to him, violates his right to free speech under the Arizona and United States Constitution. Snyder concedes that he failed to raise this issue before the Superior Court, and thus we review for fundamental error only. So basically, Snyder wants to say, oh, free speech in his appeal. But when he was fighting this case, originally, he didn't mention free speech. So they're not considering it. This argument is moot, null and void, but they're going to talk about this. Failing to raise an issue below waives your right to seek relief for all but fundamental prejudicial error. The defendant must establish error occurred that was fundamental in the nature that resulted in prejudice. Yeah, when he didn't bring up this issue, the judge can't make an error on something that you didn't even bring up in court. So, oh yeah, people need injunctions against harassment against Laura for sure, because Laura will go to people's businesses and other people. She incites stuff. So Snyder cites State v. Brown and State v. Williams, which I just whistled, which Gingras also brings up State v. Williams in his. But he brings those up to support his argument. Snyder also cites various out-of-state cases, which we find distinguishable. For example, he cites State v. Billings, which is a Connecticut appellate case from 2022, in which Connecticut Court of Appeals found that harassment statutes as applied was unconstitutional because the defendant's conviction rested solely on the content of his Facebook conversations with a third party. Unlike Arizona statute, which applies if a person contacts or causes a communication with another person. Connecticut law provides that a person commits harassment only if the person communicates with the person through one of the listed means. So maybe at that time, Connecticut didn't have a third party thing. Who knows? Thus, the Connecticut court relied on one conversation and noted the defendant did not engage with the victim's home or place of employment. All right. In contrast, Snyder not only recorded a video outside of BB's place of employment, he also tagged BB's former employer and current clients in his post and later posted the order of protection with BB's name and home address on it. Which, posting people's things, that is a foreseeable thing. As to the other out-of-state cases, they address different statutory schemes, or the court did not find the statute unconstitutional as applied to facts similar to this case. State V Shackelford, which is a North Carolina case, focusing on context as opposed to conduct, and People versus Moreno, a Colorado 2022 case, interpreting intent to harass as unconstitutionally overbroad. For example, in Moreno, the Colorado Supreme Court concluded that the phrase "in a matter intended to harass" was overbroad because it encompassed a substantial amount of protected speech and was not sufficiently narrow to render it constitutional. Conversely, Arizona's harassment statutes provide that to be punished as harassment, a communication must be in the manner that harasses, which is limited to conduct that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, seriously alarms, annoys, or harasses the person. Thus, narrows the statutory reach to avoid the more routine communications on the web, such as negative restaurant reviews, emails sent to the service provider, postings by disgruntled constitutes, or comments left on news sites, all of which concern the Colorado court. Okay. Further, the court in Shackelford addressed North Carolina's stalking statute and concluded that the statute, as applied to the defendant, focused on the content of the defendant posting at issue rather than the defendant's conduct and contacts with the victim. All right, almost done. Even if we found the cases persuasive, we have already approved Arizona harassment statutes. We conclude that they do not apply to pure First Amendment speech, but at most regulate a blend of speech and conduct, such that criminal liability is based on the manner in which certain communication is conveyed and the underlying purpose for the communication. We also note that Arizona courts have concluded that statutes similar to 132921 that prohibit certain types of communication and contain a specific intent requirement do not implicate the First Amendment. And then they cite to more, making prosecution of threats permissible so long as the state proves that the defendant had some understanding of the statement's threatening character and that a recklessness standard is enough. Requiring proof of mens rea higher than recklessness. Williams, we concluded harassment is not protected speech and that the defendant was convicted not for posting about the victim, but after the jury found he engaged in conduct that violated the Injunction Against Harassment. Snyder concedes that ARS 132921, as written, is constitutional because it satisfies the conduct requirement, but he argues that the statute as applied to him is unconstitutional because there was no evidence of any disqualifying conduct. and his conviction was based solely on the context of his speech. Not so. Any impermissible applications of the harassment statutes, if such occurs, can be addressed and cured through case-by-case analysis of specific facts. Where did it go? Okay. Here, Snyder was not prosecuted based on the context of any of his protected speech. Exactly. A footnote says Snyder failed to cite authority or develop arguments that Arizona's Constitution requires a different result than required by the First Amendment to the U.S. Constitution. Thus, he has waived any argument. Failing to develop arguments as to why the Arizona Constitution would mandate a different result than that required by the U.S. Constitutions are waived. So basically, Snyder was not convicted on anything he said in his videos. Nothing about the words he said. It was for the fact that he was where he shouldn't have been and that he tagged people and everything like that. He says so, but was prosecuted for his conduct in a harassing BB. Specifically, Snyder was convicted after a jury found he caused a harassing communication with BB in violation of the order of protection. See supra. Thus, he was neither prosecuted nor convicted based on the context of his speech, and we find no error. We affirm Snyder's convictions and sentences. So, Snyder is way different than Snyder and BB's things that are happening are way different than Owens and Hayrob. And I think it's a huge difference to me. And I would point out these differences possibly, but I hope the judge sees those things that I see, that they are in fact very different, and doesn't take, like, Gingras likes to cite things and they don't say what he thinks they say all the time. That is one thing he does. His cases do not mean what is said. All right. Let's make sure we're not missing any other breaking news before I get off of here. Let's go to... Let's go to blog. Just make sure. All right. So nothing has been updated as for now. We've shared all of the updates. Yeah, that's how I am. I'm like, oh, I can't always read it, but and I was going to post my review of it, but I'm like, no, let's go through the case because there's a lot of differences. And Gingras was like, Snyder. So now you'll know what the Snyder case is about as well. And we gain more knowledge today about Arizona and how Arizona is different maybe from other states. And the comparisons, and I see more comparisons to Snyder and Owens than I do to Snyder and Rob, but that's just me. But I hope y'all have a good evening and rest of the night. And if we get something, if we do get a ruling, then we'll be back and we will discuss it. But I will see you guys later.